Mr. Palkewala read out to us an extract from the speech of the then Law Minister, who, while speaking on the amendment to Article 31C, said that the amendment was being introduced because the government did not want the let and hindrance of fundamental rights. If Parliament has manifested a clear intention to exercise an unlimited power, it is impermissible to read down the amplitude of that power so as to make it limited. The principle of reading down cannot be invoked or applied in opposition to the clear intention of legislature. We suppose that in the history of constitutional law, no constitutional amendment has ever been read down to mean the exact opposite of what it says and intends. In fact, to accept the argument that we should read down Article 31C.
Now, this is important. So as to make it conform to the ratio of the majority decision in Peshwan and Bharti is to destroy the avowed purpose of Article 31C as indicated by the very heading, saving of certain laws under Articles 31A, 31B and 31C are grouped. Now read further.
Obliged, Your Lordship. Since the amendment to Article 31C was unquestionably made with a view to empowering the legislatures to pass laws of a particular description, even if those laws violate the discipline of 14 and 19, it seems to us impossible to hold that we should still save Article 31C from the challenge of unconstitutionality by reading into that article words which destroy the rationale of that article and an intendment which is plainly contrary to its proclaimed purpose.
Now, para 12 is your interpretation,
Yes,
right?
or I hope it.
Even if we accept it, you will have to still overcome Vaman Rao.
Yes.
So first hurdle, you have to overcome this.
Yes.
Vaman Rao.
From the aforesaid.
Yes. From the aforesaid, it is evident that Chief Justice Chandrachud expressly declined the suggestion by the learned Attorney General and learned Solicitor General to read down Article 31C to save it from being declared unconstitutional. The reasons in paragraph 65, namely to accept the suggestion and argument of reading down so that it would conform with the ratio of the majority decision in Keshav Nanda Bharati, is to destroy the above purpose of 31C as amended, indicated by the very head, saving of certain laws, makes it evident that Chief Justice Chandrachud declined the suggestion that the statute should be read down to its unamended form.
Arguing.
So, Lord, to my Lord Justice Padiwala's point, Lord, I've already said two things with regard to Vaman Rao. Lord, one, the circumstances in which it was passed. The second, the fact that it was dealing with a pre-amendment situation. And perhaps the third is that they were two...
So your argument is that Minerva Mills merely struck down Section 4.
Absolutely.
That it merely struck down Section 4 to be unconstitutional, but the entire 31C as amended.
The amended part stands struck down. That is my argument precisely. But it is not the entire 31, because 31, of course, was the subject matter of Keshav Nanda Bharati. So, my Lord, it is the amended portion
then
which
we are
stands
again
struck down.
back to square one. Then we have to only read the operative part of Minerva. There is inconsistency in your submission.
Which means 39, B and C also go. That's logically.
To be precise, come to para 15 quickly.
And if 39, B and C also go, what is the purpose of 31C?
This is what you are trying to drive.
But may I come to your Lordship in just a minute? Just a minute.
Para 15.
Please.
The argument that the order and judgment in Minerva Mills merely struck down Section 4 to be
Yes,
unconstitutional.
that is what I said.
Article 31C as amended by section is stated to be rejected.
No, your Lordship is right, my Lord. So, my Lord, I do say that Article 31C as amended has been struck down. No, my Lord, the problem, of course, my Lord, which stares all of us in the face is Keshav Nanda.
Yes. That's
It is, so my Lord, there are two ways of viewing it, to be fair. My Lord, one is, my Lord, irrespective of Keshav Nanda Bharati, 31C is struck down. The other is that the amendment in 31C is struck down. There are two ways of viewing the problem. There are two ways of viewing the problem. It is a difficult conceptual problem, but my Lord, it is there. It requires to be solved by our lordships. Now, my Lord, I just want to say two or three more things on 31C, if your lordships will permit me. Well, the NJAC judgment in 2 minutes.
Yes.
The NJAC judgment.
That's the problem we have to solve it.
But I do hope I can assist your lordship in a few minutes with that. Not the NJAC judgment. Not my short point on the NJAC judgment is this. But it is only Justice Kehar who grapples with the doctrine of revival. Point number one. But the other two learned judges, Justice Kurian and Justice Goyal, will not say that of course it must be so. But they don't actually grapple with the doctrine. So, Lord, there is no reasoning with the doctrine of revival. Justice Chalmeshwar dissents and Justice Lokur expressly says that I want to leave the question open. So, Lord, in my respectful submission, there are 2 or 3 points that emerge. The first is this, that there is no discernible ratio from the NJAC judgment. To read a single judgment in this regard, in my respectful submission.
Music to the solicitors here.
No, but on this aspect, or only on this aspect.
If that line comes in 9 judgment on the lighter side.
Not on this aspect, not on this aspect, Lord, of revival. Lord, it has no precedential value. That is the first. The second, Lord, of course, that your lordships put to me and immediately notice, the 99th amendment is not a case of substitution. It's a case of supersession, which has also been noticed in the Zail Singh case, which my lady put to me. And the substitutions which were made were merely of a consequential nature, but it was an entire independent scheme which was being put in place. So it was actually a supersession, a distinction noted in law, noted by Zail Singh's case, noted by other cases, etc. And it is not a case of a substitution. So that is what I wanted to tell your lordship very briefly with regard to the NJAC judgment. But just to conclude the 31C point, my lord. Lord, everything I have said, Lord, does not result in a constitutional vacuum. It does not result in a constitutional crisis. I take your lordships back to the words of Minerva Mills, where the learned Chief Justice, Justice Chandrachud, said that if the pith and substance of 39B is what the law is about, we have no fear of a challenge from 14 and 19. And one of the third point I leave your lordships with is that there are some possible problems with the Coelho judgment, with Article 31C, about what is the effect now of the remaining part of 31C, given the fact that 14 and 19 have now been defined as being part of the basic structure. But it is best that Parliament should re-legislate on this aspect. So that is what I wanted to say with regard to 31C. Now, a few minutes, if your lordships would indulge me, on the second aspect, which is the 39B aspect. But may I?
Yes.
39B, first point, is, can we say that the judgment in Mafatlal is actually obiter? My learned friend, the Solicitor General, did forcefully argue that in fact it was noticed and applied, and therefore it cannot be obiter.
It is discussed and applied.
But in my respectful submission, the question is whether it is obiter on this point. The point that we are discussing is whether private interest should be included within 39B. On that, it was a passing reference, merely saying that Ranganath Reddy onwards has recognized it to be so. Yes, it is true that it was then accepted as true and applied, but as far as this point is concerned, it was certainly obiter. So, it was applied in the context, as your lordship knows, of the tax which was already collected. And the question is, do you give it back to the assessee when the assessee is already passed on the burden to the customer? Or do we then distribute it for the purpose of 39B? So there was no decision on this aspect of the matter in Mafatlal. In my respectful submission, obiter it is. Now, Lord, I have got late in the day, but upon having the benefit of your lordship's points, Lord, and heard my learned friends, Lord, I want to suggest to your lordship that the problem with regard to 39B may not be such an insuperable problem. Now, I tell your lordship why. But your lordships are fully aware that there are powers of acquisition of private property. Lord, the power to make that law is under 246, read with the relevant entries in the lists. But if I'm not wrong, list 318 or something, or list 3 provides for the power of acquisition.
Entry 42 actually, 42 of list 3, acquisitioning and requisitioning of property. Entry 42.
Sorry, man. But it is definitely a power which can result in a law with regard to acquisition. Now, Lord, the suggestion that was made by some of my learned friends to say that 39B is the power to acquire, I respectfully submit is not correct. 39B is the policy that the state has to work to secure towards. It is a statement of policy which is contemplated in 39B. The Constitution has other powers which provide for acquisition. Now, Lord, my proposition to your Lordship is this, that if there is a policy which requires the acquisition of private interests, which is done in accordance with the powers of acquisition, the problem solves itself. But in this sense, that 39B at the end of the day is a policy statement. We must work towards the policy of a distribution of ownership and control of the material resources of the community. 39B by itself does not have the power of acquisition. The power of acquisition is 300A elsewhere. Once it is acquired under the provisions of 300A, the issue does not survive. So, Lord, the issue in one sense translates to this. Will you acquire for no value, or will you acquire on the principles of 300A following the due process of law? But if that is there, the question doesn't arise. So, when I request your Lordships to consider